Hello everyone, welcome back to another episode of the Darrell Brooks saga. On today's episode, we finally did it. We finally reached the verdict. Today's episode is gonna be really quick. It's not gonna be that long because, the jury basically got in there in the morning, finished signing up the forms, and got into and gave the verdict. But that's not before Darrell Brooks had a chance to go investigate and do more stuff. So let's get right to it. Before that, I want to say thank you guys for watching. Thank you guys for giving the likes. I really appreciate those. You know, maybe we have these issues with the strikes. We are hopefully we're gonna bounce back soon. So please give it a like if you can, and let's get these videos back out there. All right, but and also the playlist for these videos is in the description below, as always. Should be in the description below. With that, let's get right into the video.
Thank you. And sir, for your appearance this morning?
Just 1 second, I was certain I've been in here.
Wait, let me. I didn't have my script ready. Let me look for it. Even though it's been 2 weeks, who at this point, for something that important, doesn't have this memorized?
I'm not sure if I even have everything. I apologize for that.
There you go.
It's all right. When you're ready.
I'm here as third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all of my constitutional rights, mostly the First, the Sixth, and the 14th Amendments.
Why would you, if you're making a reservation of all your rights, why would you need to say mostly those? You're saying all of them.
Thank you. The record to reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is wearing his jail attire this morning. We are open and the jurors are here and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the Sheriff's Department is looking into that as well, but it's my understanding based on news reports that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post, if and when.
Can you imagine if they shut down Reddit because of Darrell Brooks? Oof, the world would explode. The jail would not be safe for him now.
Or I should say when the investigation is completed, I will assure the parties that you will be provided with that information.
So,
go ahead.
So it's being called a prank.
Yes.
Per the Reddit post itself, yes.
So we don't have any idea if that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the Sheriff's Department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, courtroom will remain open. I'm going to be working in my office on other things and will be available, of course, if there are any questions or if a verdict is reached. So notify the parties.
Judge.
Yes.
Go on.
No.
Go ahead.
I'm still very concerned about this whole.
Of course he's concerned about it. I mean, he had one more thing to fight about, and he actually went and did some research after that. He was like, I have to get on this. I need to be able to call for a mistrial.
Read thing after having the chance to fully read it and look at some of the language that's in it.
Fully read it, it's like a page. I read it in a minute.
It's very concerning.
That's why there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with a juror, I take that incredibly seriously, which is why I turned it over to the Sheriff's Department.
I would like Your Honor to, if it pleases the court and if it pleases Your Honor, I would like to look at some alternatives in regards to the language. I also want to state that, for the record, this did not come about from the prosecution side, from the defense's side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information that had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor,
address that for you right now if you would like.
All right. He said something about the language, so I'm gonna pull the post real quick. Give me 1 second. So let's read the actual language of the post. Okay, here it is. Let me just put it a little bit. There you go. This is the post that they. Oh, let me put my camera a little bit. You can see. You can do it with my camera right now. So this says, I am a member of the jury on this case. Here are my thoughts on the trial on this subreddit. So, to start with, I obviously shouldn't be here. I'm not allowed to look stuff up about this trial, or really have any connection with the internet, but nobody actually follows sequestering rules anyway. Hence, I am obviously posting anonymously. I accidentally wandered into here a few days ago from the subreddit drama thread on my main Reddit account. Here's my opinion on this thread. So first of all, you think that if this were a juror, he will find it in the drama section. He will go straight to the post if he wanted to say something. But okay. First off, it's pretty obvious due to the chain of custody that the defendant is in fact Mr. Brooks, and he did do it. However, I've had throughout this trial doubts about various aspects of the case. Number 1, the jury is clearly biased against Mr. Brooks. I got that feeling from when we were in the room, and my eyes have been open to how she acted towards him when the jury was out of the room. So this is someone who was able to see stuff when they were outside of the room. So not a juror, because they were not on that. Basically, they were not present when they were out of the room, obviously. So let's keep going. 2. I don't know. Clearly, she's not an impartial judge, and has been trying to belittle, demean, bully, and pull procedural tricks on him fairly frequently. I had my doubts already, but the subreddit has shown it to me clearly. Number 2, Mr. Brooks has clearly not been given the chance to plead his case in court. He has been silenced and mocked at almost every turn. While he may be a bit loud and crass, I still believe his side deserves to be heard. There's no side. When he had the opportunity to present his argument, but he decided to not do it. I do have significant doubts about the subject matter jurisdiction. I didn't understand it when it was discussed in court because the defendant was repeatedly silenced, but I do understand now thanks to this sub, and I agree that the subject matter jurisdiction is a great concern here. Again, that's not something that they have to and understand. That's not for the jury to understand. That's a legal issue. It doesn't matter to them. This subreddit has made me aware of jury nullification, and I'm very grateful for that. Overall, I'm not sure what I will decide. I'm not educated in law, and I have to admit I am biased against the defendant for the horrible acts he did. That's not being biased. That's just looking at the facts and just go with them. However, it is also clear that this trial is a complete kangaroo court. Mr. Brooks has not been allowed to try to prove his innocence, subject matter jurisdiction, or explain the circumstances surrounding the events. It's hard to imagine what could justify it, but we just can't know because of this trial. For these reasons, I'm torn between locking him up and throwing away the key or jury nullification. Both have arguments for and against them, and I'm not looking forward to choosing. I'm mostly writing this to help me process my thoughts on this, but please let me know what you think. So, that was the Reddit post. That was what he took so long to read, I guess. But let's see how he finds stuff to argue for it.
Yeah, if it pleases Your Honor, I would like to request some alternatives to this issue.
What's your specific request?
My specific request would be to look into a mistrial. I was looking at some, obviously.
So, notice how he doesn't say, "What's your request? I want a mistrial." No, he starts talking about, "Oh, I was looking at this. I was looking at that." So just say what you want.
Yesterday was very, very long for everybody. And as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
Go for it.
United States versus Perez, 22 U.S. 579. That one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references. Also,
he has no idea what he's talking about.
Looked at Brown versus Rushton, 572 F.3D 198. Speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates. That's BATES. 917 F2D 388. Specifically, it says if an impartial verdict can be reached, or if a verdict of conviction could be reached but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 U.S. 497. It says neither party in a case has a right to have his case decided by a jury which may be tainted by bias, and I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing.
How do you know? You're stating a fact when you don't know.
To do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor, it's pretty clear that this, if not directly came from a juror who sits on this panel. It came from someone who sits in this courtroom every single day.
No. I'm watching you on YouTube. Everyone was watching you on YouTube when this happened. That's you're simply incorrect about that.
The language directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning.
Tell me that. We just read together that Reddit post. Do you guys think that any of that was something that we didn't know before just watching the trial on YouTube? Do you think that any of that information was secret?
Extremely concerning. And then going back to some of these case laws that I cited, it talks about something to the effect of the ends of public justice.
What?
But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it.
You don't know how to interpret anything.
Obviously, I'm not educated in a lot of...
You can stop right there. You don't need to clarify more.
The law is in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at some options, look at some alternatives. And those case laws I cited talks specifically about that. I'm extremely concerned about this.
Extremely.
If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here in these case laws and.
What's the request though that you're making based upon the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You say request for
relief?
You've been in trial for 2 weeks, and you still don't know what a request for relief is?
Relief?
And what are you asking me to do based upon the information that the limited information we have about the Reddit post and this trial?
I guess my request would be, because of the concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time.
At the very least.
So this can be resolved. This is alarming, to say the least. I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know who. Well, I think the name of the person who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions. And I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming.
It's not alarming. Nothing that the post says. I don't think I read it, and we read it right now, and I don't think nothing of that makes it something that only a juror will know.
Very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That post was edited last night, claiming that it was a prank from the start, and that the original poster was didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
So there you go. Darrell talk about the Reddit post for like half an hour, and in less than a minute, Zach was just like, you know what? No, the way that the site works is that the person that made the post is the one that can modify it, and our jurors doesn't have their phones or any access to the internet, so there couldn't be any of them. Boom.
I object to that on the grounds, Your Honor, that, like you just said, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss.
Well, there's an investigation going, but when they see what Zach said, that the investigator is going to be like, oh, someone modified the post, and the jurors doesn't have any access to electronics. That means that they're not it. Case closed.
We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. It's unfair to say that the issue was put to bed when there's still so many questions left. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever it is, thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I mean, common sense would tell you that this is someone who's very close to the case, whether they were intending to be funny, whether they were intending to try to prank the court or anything like that. We don't know. That could be anybody's guess. They point to certain language in the case. They make references to saying when we were in the room. They got certain feelings from when
Yes, when the jurors. That's what they mean by we.
Where they specifically refer to themselves and a group. That would be we.
Yes, all the jurors. What do you mean?
Plural.
I'm surprised he knows the word plural.
They say, I have to admit I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. If this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on. Clearly. There's no other way to interpret this. This is clearly someone close to the case. And
Nah, Brooks. All of the trial was televised. All of the trial was followed by many people who are way more detail oriented than me. They know about it.
I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone on the jury, or what if it turns out that more people are involved in it than just whoever this anonymous person was who left the post? It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks.
Yes.
And even in court days leading up to the trial, we've never had anything like this happen. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? I mean, it begs so many questions. It's too.
And notice how he's not addressing what Zach said. Yes, he's not addressing the fact that you cannot modify the post if you're not that person.
Uncertain. It's too concerning. It's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let them." No, there has to be some type of alternatives, and something has to be done.
Something is being done. An investigation is being done, and that's what it needs to happen.
And if that's a mistrial, if that's discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at, if anything, to protect the integrity of the trial. I find it very hard to believe that this close to the trial being over, and all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
To you.
Well, let me address your concerns, sir. I cannot make conclusions at this point about whether this is legitimate or prank. The forensic unit with the Sheriff's Department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. You've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now the record is speculative. There are no facts to support a mistrial or discharging the jury. I certainly will take time to look at the cases you have cited to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. That is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks, so go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes, and he declined, so I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes if that occurs, if he chooses to.
It's a good point to bring.
Notice how she phrased it. He needs to be in that if he chooses to. He didn't say he needs to. If he wants to, he needs. But
Bring up, it is possible the jury would need to be brought out if there is any question that I need to answer on the record. Of course, they'll come out if and when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the Sheriff's Department to make that available for you, should you choose.
Isn't it my choice?
Yes, it
Sure.
is.
So why do I need to be in street clothes? Why does that need to be on the record? That
Your choice should be placed on the record, sir.
If not, I was offered to be in street clothes. If I made it the choice.
Do you dispute that, sir?
Yes, I dispute it because it's my choice.
he has no idea what dispute means.
Well, no.
At
Do
this
you
point-
dispute that you were
at this
given
point,
the
there's
choice
no-
this morning?
At this point, there's no reason why that should be on the record. That if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if
Why?
you were to challenge that you and claim that you were required to wear your jail uniform or jail attire. You're not required. This
didn't
is
make
a
that
trial.
request.
You have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice, of course.
So why does that need to be stated for the record?
I just
Why-
indicated why, sir. So,
I don't see the relevancy of it.
all right. At this point,
So what does it matter? It just is. And now you can move on.
Unless there are any
raised.
further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates
There-
with us, either about a question or verdicts.
There is something that needs to be addressed. Subject matter jurisdiction.
The
Why
court
hasn't-
declines that. I'm stepping off.
Why hasn't it been proven on the record yet? And I object.
I love that now that the trial is over, she's just like, I'm not addressing it. I'm out. See ya.
Appearances are as they were before. I would make just one note that Mr. Brooks is now present in a suit, and I will also
After fighting about what Susan said, he's now actually put on a suit.
advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter, and without anything further, I'll have the jury brought out.
Boom.
Your Honor, I don't consent to being called that name and would like to address subject matter jurisdiction for the record that has yet to be proven.
Your objections are noted. I will not be addressing subject matter jurisdiction. Please bring the jury out.
Would it be proven for the record, Your Honor?
What part of I'm not addressing it? You don't understand.
Just a reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain from audible responses. Any disruptions may result in removal from the courtroom.
There is one disruption when they read the verdict, and I'm gonna leave it in. You know that I don't use adult language in these videos, but they are gonna say it, not me.
Your Honor, is that a tacit agreement not to address subject matter jurisdiction for the record?
No, she already said
Jury's
she's
coming
not gonna
in.
address
All
it.
rise, please.
How can it be
I
tacit if she already said
respectfully
no?
object to that ruling, Your Honor, and request the legal reconsideration of your ruling for the record.
Your requests are noted, sir. I will not be addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor?
So what you want?
Is that a tacit agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor?
There was
For
no
the
question.
record, may I request the legal or factual basis for your ruling, Your Honor?
You think that right now he's trying to get himself thrown to the other courtroom to delay more? Because that's the only thing that I can say about him stating all of this.
It might have been a false alarm.
For the record, may I respectfully
Would be
request
first.
a written judicial finding of fact and conclusion of law on this issue, Your Honor?
All your requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
Denied.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Denied.
Based on what law or fact, Your Honor? Is that a tacit agreement that you don't have to answer that question? For the record, Your Honor, as a public servant? You don't have to address admiralty law or common law if this court is operating under admiralty law?
Will not be addressing any of those issues. Thank
Respectfully
you, everyone.
object,
Please
Your
be
Honor.
seated. Ladies and gentlemen of the jury, have you picked one among you to be the foreperson? All right, and I see it's your number 11. Have you reached verdicts on all 76 counts? Yes. Please hand all of the forms to the bailiff.
76 counts. And look how he's scanning the jury. He's trying to see if anyone's gonna give him the and not something to be like,
Your
I got
understanding
you.
is that we've reached the verdict. Is it necessary that I have these shock devices on my ankles?
And it brings the shock devices again. That's gonna be an issue for a future video. And right now she's focused, laser focused on just getting those verdicts ready. And that was a lot, 76 one. She has to separate the guilty and the ones that
have
they didn't.
confirmed that there are 76 signed verdicts and 76 unsigned verdicts. Which would be what I would expect.
Look at that pile of files, and she has to read every one of those.
All right, I will read each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
That's when it starts to set in on this after the first one was like a shock. He couldn't process it right there, and when she read the second one, he was like, oh, so I'm done.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that.
And he said what many of the families wanted to say to him, and I think he's glad that he was removed. He doesn't mind.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. Of first-degree intentional homicide as charged in count 4.
Notice that he doesn't cry. Notice that he's not remorseful. He just lays his head down and that's it. And I'm gonna skip a little bit ahead because it's just she reading more and more. It's the same. Like he just goes into this position and then he continues.
Dated today's date and signed by the foreperson. Did the defendant... We, the jury, find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information. Dated today's date and signed by the foreperson. Mr. Brooks, would you like me to poll the jury?
His last opportunity, his last chance.
Members of the jury, I'm going to ask each one of you individually to stand up, identify your number for the record, and then state whether the verdicts read in open court are your true verdicts. I'll start with the foreperson. And I'll read your numbers first so it's a little bit easier. So juror number 11.
And he look at those eyes. He's like, okay, now I have a chance. If any of them says that's not his decision, I can still get free.
Were the verdicts read in open court, or are the verdicts... Let me rephrase that. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 3. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 6. The verdicts read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdict...
He looks at them. He looks at all of them and he's like, please just say no.
read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 19. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 34. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 41. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 45. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 46. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 48. The verdicts read in open court, are those your true verdicts?
They are, Your Honor.
Thank you. Juror number 51. The verdicts read in open court, are those your true verdicts?
Yes.
Mr. Brooks, are you satisfied with the polling of the jurors?
No.
No.
I'm sorry?
No.
The court is so satisfied with the polling of the jurors. The court now accepts the verdicts. Ladies and gentlemen, on behalf of myself, the citizens of Waukesha County, and both parties here, I want to thank you for the time and attention that you've spent on this case. Your service in this case is now concluded. There is no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. On behalf, again, of the court and all of the parties, we thank you for your service over the last 3.5 weeks. You are discharged and free to go.
They did it.
All rise for the jury, please.
But you could nullify, guys. You could nullify that sentence.
Anything from the state at this time?
Your Honor, the state moves for judgment on the verdict as to each and every count.
Anything from you, Mr. Brooks?
What is judgment?
What is judgment? It means that you're gonna get judged. The judge now gets to participate and tell you what you're gonna be spending your life on.
Given the verdicts from the jury here today, the court will enter judgments of conviction based upon the verdicts on all 76 counts. Court will also revoke bond. In this case, I plan on bringing the case in Monday, this coming Monday, the 31st at 1 p.m. to address further scheduling. What I would ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf, if so, how many, how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon case. All right then, thank you everyone. We are adjourned for today. We'll see you all on Monday.
All right, and that's basically the trial. Now we go into judgment. So, thank you guys for watching. I'll see you guys on the next episode. Thank you. Give it a like if you make it this far. Have a wonderful day. Bye bye.